and the courts and judges engage in the kind of training, for example, identified in the O'Malley report, but others. The court modernization program delivers on its promise. All of that happens. And we're sitting here, shall we say, in perhaps 2028, and we're looking back and we say, okay, there was the odd bump in the road, not everything worked perfectly, things needed to be tweaked, but in the round, what was promised happened. But we still have problems. And what we're trying to do today is to identify what those problems might be, and perhaps to try and begin to think about how those problems can be solved now, rather than waiting until 2028 to say, well, actually, that was all great and things are better, but they're far from the way we'd like them to be. And we're now going to start to address those problems. So that's an oversimplified question that each of the workshops in their own way will seek to identify. And I can think of no better person to give us an introduction to the themes of those workshops than Eilish Barry, and of course in her role as representing FLAC. I was sort of qualifying around the time FLAC got off the ground. It was initially, I think, just a group of young lawyers who were providing free legal assistance to individuals who couldn't afford assistance of their own. But it's of course grown into an organization which also does research and advocacy in this field. And therefore I can think of no better organization with its track record to give us an overview of the difficult issues of unmet legal access to justice issues, and to perhaps lay the groundwork for the workshops, and perhaps in turn the groundwork for a roadmap to beginning to address some of those issues. So with that said, I'll hand over the floor to Eilish.
Good morning, everyone. Before I begin, I just want to add my voice to the chorus of tributes being paid to the Chief Justice, who's been a great friend to FLAC. He has consistently highlighted the need for broader and better legal aid at every opportunity since the statement for the new legal year in 2017, where he committed to making access to justice a central focus of his tenure, including the launch of the annual reports of FLAC, our colleagues in the Mercy Law Centre and CLM, and in the opening address of FLAC's Access to Justice Conference in 2019, and at the 40th anniversary of the Legal Aid Board. FLAC is really proud to be part of his Access to Justice Committee. I also want to pay tribute to Judge McMenamin, who's a driving force on the committee, whose signature I recently noticed is on the articles and memo of FLAC. We've been campaigning, as Judge Clark said, for 50 years for access to justice, so it's really encouraging to have two Supreme Court judges with such an interest and commitment to access to justice. I also want to echo the thanks and acknowledgements of the huge work that my colleagues on the committee have been engaged in. Tractor O'Regan from the Law Society with her colleague Anne Chute, Joseph O'Sullivan from the Bar, and both bodies have always been very supportive of FLAC's work in terms of funding, volunteering in FLAC clinics, and their endorsement and support of the very recently launched Pro Bono Pledge. I'm sad to hear that our colleague on the committee is that Access to Justice will be losing a champion in that Philip O'Leary will shortly be stepping down as chair of the Legal Aid Board. I know how passionately he cares about access to justice. It was Philip who suggested having Mark Benton at this conference and who pointed us in the direction of Canada, which offers the way forward to unmet legal needs in a number of critical respects. Sinead Lucy, who's with us here today, our managing solicitor, recently emailed me that Canadians are cool, which pretty much sums up what I want to say this morning. I also want to thank the incredibly efficient and effective Sarah Rose Murphy and Patrick Comboy from the Chief Justice's office, who's made it all extremely pleasant and fun. And it was really nice to meet everyone in person yesterday. I was very struck by the amount of people who contacted me who wanted to speak and to contribute to today's events. Normally, FLAC has to strong-arm people into speaking, but we have turned away a number of people who wanted to contribute as panelists who I hope are here today. I think that's indicative of that desire for change that was so evident at yesterday's event. Change is definitely in the air. A number of the issues we highlighted at our Access to Justice conference in 2019 will be examined in some of the breakout sessions this morning, and they've been reflected already in the changes that are happening that we heard about yesterday. We've campaigned for a review of the legal aid system, delighted that it's about to happen, and noticed that the Minister mentioned it yesterday, but I would love to have heard more detail about the scope and nature of the review. A number of FLAC staff have been delighted to engage in consultation in relation to the Courts Services Modernisation Programme that Angela Denning spoke about. There seems to be a really welcome cultural change within the court services, a real openness, which is very striking. And we look forward to ongoing consultations, especially in relation to issues like lay litigants, reform of rules of procedures on online hearings, and would be delighted to be part of the coalition of reformers that Angela referred to yesterday. Professor McKeever's research on litigants in person is a really important contribution to the modernisation programme, and I'm delighted that she's contributing to Workshop D. We also welcome the long overdue reform of the family justice system that has been referred to, albeit that we have some concerns that some of the hard-won legal rights and protections may be lost sight of in the embrace of mediation as the almost only solution to family law issues. I practiced family law years ago before the current legislative architecture of protections designed mainly for dependent women and children was introduced, and it was grim. It is vital that legal advice be readily available as to what people's rights are and what would be the likely outcomes in a court situation before mediation starts, especially in relation to issues like the implications of pension adjustment orders, transfer of family homes, and the implications of any settlements on social welfare rights. I'm uneasy at the notion of people in domestic violence situations or where there's a huge disparity in power and resources and where coercive control may be silently present, being unduly pressurized into mediation, where it is not the job of the mediator to ensure and enforce the protection of rights of our vulnerable and dependent adults and children. And we look forward to more consultation in that regard. FLAC contributed to the review of the administration of justice, and we welcome a number of its recommendations. However, we have sought consultation in relation to the implementation of some of its recommendations. Civil society was not strongly represented on the review group, which we regret, and I was especially dismayed to hear from the Minister yesterday that legislation is planned in relation to judicial review, as we have particular concerns about these recommendations being implemented. We very much welcome the proposed long overdue reform of rules and procedures, which are a key part of the barriers inhibiting access to justice. But we have some concern that the review recommendations, if implemented in their current form, will put too much of an onus on an unrepresented litigant to identify with clarity what their claim is. It is vital that these reforms are equality, human rights and poverty proofed, as is required by Section 42 of the Irish Human Rights and Equality Commission Act. There's a growing understanding of the implication of this public sector equality and human rights duty for statutory bodies like the court services. And FLAC will shortly be publishing a report on its implications for the court services, the WRC and the Legal Aid Board, which draws very heavily on learning from the UK, especially in relation to the Equal Treatment Bench Book. And we're really lucky today to have Judge Tamara Lewis, who is heavily involved in the revised Equal Treatment Bench Book with us today, along with Chief Commissioner Sinead Gibney from IREC at Workshop F. We noticed and were pleased that the WRC are providing their adjudicators with a section of the UK Equal Treatment Bench Book on catering for lay litigants. Another significant development that FLAC has been proud to be associated with has been the embedding of pro bono in Ireland, with the launch of the Pro Bono Pledge in 2020, which asked the legal profession to commit to provide a minimum aspirational target of 20 hours pro bono per lawyer per year. The pledge was developed by an independent group of law firms, barristers and in-house legal teams, and is coordinated by FLAC's Public Interest Law Project, PILA, and to date 2,500 legal practitioners have signed up to it. In addition to the two pro bono associates, Ethna Lynch and Carl-Ann Minnick, who are also great friends of FLAC, for the first time a pro bono partner has been appointed, and I want to congratulate Niamh Coonahan from Matheson's in that regard. I'm also delighted that Eamon Carroll, who has really got pro bono off the ground in Ireland, will be speaking at Workshop D. FLAC is also pleased at the recent establishment of a dedicated legal service for travellers, albeit we only have one solicitor working in it. We also enjoy a partnership with the Traveller Equality and Justice Project in UCC, and both Dr. Fiona Donson and Mark Willers QC, who serve on its advisory board of the partnership, are with us today. The Centre for Environmental Justice, established by CLM, is a very significant welcome development. And as Judge O'Leary pointed out yesterday, the Aarhus Convention requirements are gold standard in terms of access to justice. And I'm delighted to welcome Anya Ryle as moderator for that workshop. Yesterday, as the Chief Justice said, we heard the moral, legal, social and economic imperatives for access to justice. A strong civil justice scheme is an important part of the foundation of civil society, the platform on which we build everything else. It's obviously important for the individual, but it has a far broader societal impact. It increases social inclusion, it's foundational to democracy and the rule of law, and a vital tool in holding the state and other powerful bodies to account, as Judge O'Leary illustrated yesterday, quoting the UK Supreme Court. Recent research also shows that improved access to justice results in positive health outcomes. It was fantastic to hear from Professor Farrow about the research that shows that for every dollar invested in access to justice, there's a $9 to $15 return. And I'm only sorry we didn't invite deeper today and yesterday to hear Professor Farrow. The Cost of Justice project of the Canadian Forum on Civil Justice shows the enormous social cost we are incurring because we do not have a sufficiently effective justice system. The reality here in Ireland is that we have no way of measuring the enormous social cost in not having a sufficiently effective system, though FLAC witnesses that social cost every day on our phone line, in the Traveller Legal Service, in our Roma clinics, and the policy work we do, especially in relation to debt. We would like to see access to justice being made a central focus for all the reform that is happening. And to borrow further from Professor Farrow's research, where he talks about the gaps between ideas and implementation, what he calls the implementation gap. Change won't happen just because people want to. One important factor which he identifies as contributing to the implementation gap, and which we experience in FLAC, is a lack of public interest and support for access to justice. We know in Ireland that the attitude of some of the public and some civil servants is to equate access to justice with money for lawyers. Professor Farrow's research highlighting the economic and social benefits will hopefully result in a seismic change in attitude in this regard. In our legal aid campaign, we've been engaging with NGOs about their experience of legal aid, and it is striking, as Professor Farrow said yesterday, how very quickly people become interested in it and see how relevant it is and what a vital part of society it should be. Another reason suggested by Professor Farrow for the implementation gap is that some of the problems we face are intricate systemic issues, and leadership of our civil justice system is diffuse. It's difficult to say that there's one civil justice system, but more accurate to say that there are several systems and parts of systems with important elements of the systems and systems having a large measure of independence from each other. So you have judges as independent decision makers, other quasi-judicial bodies like the WRC or the Social Welfare Appeals Office, lawyers as independent advocates with their professional bodies, and most recently the LSRA with its new functions. You have the court services, the Office for Public Works, the Legal Aid Board, the Department of Justice, and deeper holding the financial strings. FLAC would like to include relevant bodies like the Citizens Information Board, the Law Reform Commission, and FLAC and the other independent law centres as elements. There is no one group in charge of or with power, capacity and resources to cure the systemic problems. And to me, that is why for FLAC, the Chief Justice's Access to Justice Committee is so important, as it brings some of the key players together. And I'm really happy that such a broad range of most of the key actors have been at this conference yesterday and today. But we need to do more than just talk about an effective civil justice system. We need a civil justice movement which engages the public and all of the key players in the justice system. We need a broad-based access to justice campaign that is similar to the government-led campaign for Ireland to become the EU's dispute resolution forum of choice following Brexit. It was very striking to see how players were able to come together to promote that initiative, including the Attorney General. The Canadian Action Committee on Access to Civil and Family Matters brings people from all corners of Canada's justice system together to propose and examine approaches on this critical issue. It has adopted justice development goals, and progress on those goals are published annually. Its Action Committee coordinates national metrics on justice and connects people to share innovations throughout the year and at its annual summit. I would hope that one legacy of this conference would be that the Chief Justice's Access to Justice Committee could be developed into a more formal, broad-based committee involving all of the key players from Ireland's justice system who have been at this conference, along the lines of the Canadian model, with action plans, goals, and indicators. In talking about unmet legal needs, the nature and level of unmet legal need in Ireland is neither well understood or comprehensively researched. We have empirically very little data about legal need, the social and financial impact of unmet legal need referred to by Professor Farrell. We have no idea of the actual volume of legal need and no idea of the volume of unmet legal need and the extent of the social and financial consequences. Historically, legal services and the legal education sectors have placed very little emphasis on the importance of evidence-based approach to the design and delivery of services. Yesterday, the Chief Justice pointed out the similarities between family law and commercial law, but there is something deeply uncomfortable about having a state-of-the-art commercial court in comparative luxury compared to the state of the completely overstretched family law district court across the river. Research is vital to help us understand where legal needs are, and it's necessary to prioritise resources accordingly. I'd like to highlight two different aspects of unmet needs, which our legal system and our legal aid system is particularly ill-equipped to deal with. Luke Clements from the Legal Action Group in the UK has written about what he calls clustered injustice. The people who live with disadvantage experience clusters of associated legal problems, either at the same time or consecutively. Commonly experienced legal problems can coalesce into clusters. The experience of one problem can lead to another in snowballing effect. You lose your job, you lose you can't pay your mortgage, you lose your house, you get evicted, you become homeless. Solving one problem does not necessarily mean the end of all legal issues. For many people living in disadvantage, their legal problems are multiple, interconnected, and messy. People living with disadvantage are constantly involved with the law in its most intrusive form. When I read that, I felt like he must have been sitting, writing his book in the FLAC office. We saw it so vividly with our client with Down syndrome, when the response to him wanting to marry his partner was to initiate wardship proceedings. We also see it on a daily basis in the Traveller Legal Service, where the daily lives of travellers constantly barge up against sharp legal things like summary evictions, discrimination, and the criminalisation of their way of life. Clements says that people most likely to experience multiple legal problems include, and the list is long, lone parents, people in local authority housing, adults with long-standing illnesses or disability, and adults on mean-tested payments, people with significant debt problems. FLAC would like to add to this list people under 25 on social welfare payments, homeless people, children with disabilities, people living in direct provision, people who fall foul of the immigration system, and ethnic minorities, and people who have difficulty satisfying the habitual residence test that governs so much of our social protection legislation. The second area of unmet legal need that our legal system is ill-equipped to deal with are what academics call diffuse or collective rights, that are rights that are shared by everyone, but are far too onerous for one individual to enforce. And I'm talking here about environmental rights, privacy rights, or systemic discrimination. In looking at unmet legal needs, FLAC has always maintained that access to justice is a continuum of issues. It includes information, legal advice, advocacy, access to the courts, access to effective remedies, and fair and just laws. Unmet legal needs arise at each point of this continuum, and viewing unmet legal need as a continuum and committing to address the needs earlier could have a tremendous implication for costs. Broadening accessibility to legal information and advice should be the #1 priority. What the FLAC telephone information line tells us about people who know they may have a legal issue is that there's a huge unmet legal need for legal information and advice, especially in the areas of family and employment law, which is not otherwise available. This phone line is only reaching the tip of the iceberg in this regard, and we know and regret that very many people can't get through to our information line. Unfortunately, for many people who contact FLAC, FLAC may be the first and only port of call due to the inadequacies in the legal aid system. At the end of May 2020, for the first time, employment law topped the area of queries, which is the first time in FLAC's history of recording the queries. What is most worrying is that due to the inadequate legal aid scheme, there is nowhere to send them for further advice and representation. There may be a possibility of getting legal aid in family cases, but we are seeing again and again lots of people who may be outside the very strict means test and who have no hope of being able to pay for a solicitor. There is no legal aid in employment cases, so there is nowhere to refer the almost 2,000 people who got through to us on the phone line last year with quite often complex employment law issues. We also know from our work as the Law Centre the acute needs of people who live in disadvantage for information and advice and advocacy in circumstances where they may have no idea what the legal issues are or how the law can help. In Canada, the BC legal aid system has a requirement to be flexible and innovative, and they have multiple ways of getting information across, both to people who know they have legal issues and those who don't, including legal information, outreach workers, Aboriginal community legal workers, and their system actively supports community partners and community workers, a vastly different model to our own legal aid system. Recent academic research, and there isn't a lot of it, and I don't pretend to have researched it comprehensively, but recent research on the best ways to provide access to justice to people living in disadvantage recommends that it should be provided by small, local, independent services. People who know best about housing, social welfare, debt and discrimination are the best place to provide practical early advice to support people whose problems are messy and multiple. To me, that's not reinventing the wheel. That's what the Pringle report recommended 40 years ago, a network of community law centres. When I hear small, local and independent, I think immediately of Dave Ellis in what was then called Coolock Community Law Centre, who was determined not to do traditional litigation, but focused on welfare rights, community education and training. A network of community law centres would also be a comparatively cheap and highly effective way of trying to meet unmet legal need for people living in disadvantage. It also strikes me that the Citizens Information Board, with their huge range and network of citizens information centres all around the country, are very well placed to have community legal officers and outreach legal workers who could also have relevant expertise and be supported by a reformed legal aid board. And I welcome Michael Owens from the Citizens Information Board here today. The problems, as was said yesterday, with the legal aid system are well documented, and there remains very serious and significant gaps in our legal aid system, both in terms of the limited coverage, which is defined by extensive exclusions, and the strict requirements of financial eligibility. There is a perception that legal aid is not available in one of the biggest issues of the day, homelessness, and that, as I said before, there's no legal aid for employment or discrimination claims, no matter how complex the issue or how vulnerable the claimants may be. Our legal aid system is particularly unsuited to deal with people with multiple legal issues and collective rights, as its focus is predominantly on family law. But it makes no sense that it's not proactively involved in the provision of early legal information. It makes no sense that it cannot represent its family law clients in their related social welfare appeals, their claims before the WRC, or represent them in repossession hearings when their homes are being repossessed. FLAC, together with 48 NGOs, have campaigned that the proposed review of legal aid be a root and branch review that will scope and map unmet legal need. That review should explore all of the functions of the Legal Aid Board, such as the provision of information, advocacy, education and research, obviously the eligibility criteria for legal aid, including the means test, and the areas of law covered, and in particular, how services should be delivered, such as community law centres, targeted or specialised legal services for disadvantaged groups, and a variety of ways of providing early legal information and advice. We also called for the review to be chaired by a person of status, such as a judge with a particular interest in access to justice, such as occurred with the original Pringle Committee, and to have at its centre the voices of those who experience unmet legal need and involve key stakeholders. The review also needs to measure the civil legal aid system against the international standards and compliance with the state's obligations under national and international human rights laws, which were so comprehensively identified by Judge O'Leary yesterday. Part of the continuum of access to justice includes access to courts and effective remedies, and I've mentioned already the need for accessible rules and procedures and the need to provide for lay litigants. It's for another day to examine which rights get adjudicated on in which fora, but it is to be regretted that the review of the administration of justice did not deal with the urgently needed reform of the vast array of quasi-judicial bodies, as these are where for the most part, the rights of disadvantaged people are adjudicated on. Such a review is even more urgently needed in light of the Saluski judgment. And I know this is one issue that the Law Reform Commission is looking at. Even if you're lucky enough to get legal representation, there is no real equality of arms beyond a strict procedural equality of arms, especially if you're up against the state with its ample pockets, or local authorities, or large corporate entities like social media giants. The procedural rules on standing, costs, class actions and multi-party actions may restrict the ability of people living in disadvantage from making or defending claims, especially where rights are held collectively, like the environment and privacy and systemic discrimination. Some practice directions in relation to immigration have also proved particularly problematic. We have previously expressed concern about the use of very strict confidentiality clauses by a state department, which binds claimants and their legal representatives to absolute confidentiality and effectively allows the state to continue on with the alleged illegal behaviour. This practice is also a very bad use of court time, and there should be some better procedure for public interest matters to be adjudicated on, even if settled. The last part of the access to justice continuum are fair and just laws. We have laws in place that criminalise the way of life of travellers, and some laws governing eviction can result in summary evictions without any meaningful opportunity for access to legal advice, let alone access to legal aid. These laws have been condemned by international human rights bodies but remain unamended. In conclusion, we need research to measure the volume and type of legal need, and in particular unmet legal need, especially for people living in a disadvantage, so that we have evidence-led approaches to the design and delivery of legal services. We need a reformed, flexible legal aid system that can provide small, independent local services and which prioritise advice and information in accessible ways for people who know, and more particularly people who don't know what legal issues they may have. This would include a network of community law centres, and have people with expertise in areas such as housing, social welfare, and debt and discrimination. We need a more formal, broad-based forum for dealing with access to justice, which brings together people from all corners of the justice system, many of whom are here today and have expressed a desire to change. We undervalue access to justice if we don't move from ideas to implementation. Let's form a coalition of reformers, as Angela said yesterday, to implement the great ideas we're going to hear. Thank you very much.
Thank you very much, Eilish.
Well, good afternoon, everybody, and welcome back to this plenary session. My name is Jerry White, and I've been asked to chair this session in which we get feedback from the different workshops. And if the other workshops were as informative and as thought-provoking as the two that I was fortunate enough to attend, then we're going to do some serious learning in this session. The schedule is tight, though. We've half an hour to hear about the 6 different workshops, and so I'm going to ask each moderator to speak for no more than 5 minutes. And so without any further ado, I'm going to call on Sinead Lucy, Managing Solicitor for FLAC, who is the moderator of Workshop A on Awareness and Information. So Sinead, over to you.
Thanks very much, Jerry. We had a very lively and interesting workshop looking at information and awareness this morning. So we had 6 speakers. We kicked off with Michael Owens from the Citizens Information Board, who spoke about the variety of services provided by the Citizens Information Board. He spoke particularly about some of the issues coming up in the last year during COVID-19, such as mortgage arrears and employment and unemployment issues emerging as huge areas of concern for individuals. He gave us some statistics about the reach of their services, and I didn't catch them all, unfortunately. But what did seem remarkable to me was that he spoke about their website, the Citizens Information website, having 1.5 million hits in the last year. So that just gives a sense of the scope of the reach of that service and the online information that's provided. He also did speak, however, about the importance of face-to-face services, information and advice giving. He spoke about some of the specialized services they provided as well, and this is very much speaks to how they target certain services to certain communities of need. So he spoke about the National Advocacy Service for persons with disabilities, the Money Advice and Budgeting Services that also has a specific service for travellers. He spoke as well about the role of the advocate, and I suppose what came from that in terms of the advocacy services that CIB provides is that an advocate can achieve quite a lot in terms of ensuring that an individual can vindicate their rights before they ever have to resort to a solicitor or legal services. So I think that's a key takeaway from that in terms of advocacy services. We then moved on and we spoke to 2 independent law centres, one based in Dublin and Limerick, and that's Community Law and Mediation, and the other was in British Columbia. So Rose Wall spoke to us from CLM based in Coolock and Limerick First. And she spoke about the role of the Community Law Centre in providing community legal education, and very far from a passive legal service where people have to come in and get information and services. They very much there go out to the community. So wherever the community is, CLM will link with that in order to educate the community in relation to their legal rights. So she spoke about going to libraries, family resource centres. She even spoke about going to a line dancing event. So that the focus is very much on empowering the community in terms of legal information and education, and that then links on the continuum to advocacy and representation. Then we spoke to Mark Benton in British Columbia, and he is the CEO, I better get the name right, of the Legal Services Society in British Columbia. And that's a very interesting model.
Sinead, you've 1 minute. Thank you.
1 minute, okay. Well, it's a mixed statutory and independent model of information provision, and I would urge people to go onto their website just to see how they provide information to the public. And he spoke about the fact that they reach 10 times more people through their information provision than through their legal services. We then spoke about law reform, and Raymond Byrne spoke about the role of modernising law and democratising law and the work of the Law Reform Commission in that regard and making it fit for the 21st century. So it's not only available to lawyers, but also to everyone. We then had Marianne from the court service, and she spoke about the huge cultural change there, I think, in looking at the modernization processes and looking at the needs of end users. So there's a huge consultation process there, and looking at the needs of lay litigants in terms of the barriers they experience engaging with the court service. And again, their website will be a resource for information on that process. Finally, we had a presentation from Colleen Dube from NALA, and that very much linked back to all the other presentations. And she was raising awareness about the use of plain language and making information accessible, moving away from legalese and making it accessible in society where so many people suffer from literacy issues. I'm going to make one small final point that Colleen didn't have time to fully expand on, but she also spoke about the digital divide and the fact that in all the rush to modernization, a lot of people aren't digitally literate, and that we all need to bear that in mind. And she gave a particular example about GDPR. So we didn't have enough time to get into, we really only scratched the surface of the topic. There were other comments and there was chat going on the side that also fed in and would be worth capturing, but I know I've run out of time at this stage. So thank you very much, Jerry.
Thank you very much, Sinead. The second workshop was on access to justice in environmental matters, and I'm going to ask the moderator there, Professor Anya Ryle from the School of Law of UCC, to speak to us now about that.
Thank you very much, Jerry. We had a very interesting workshop on access to environmental justice, and we had over 50 people in the session, which is, I think, always a good sign early on a Saturday morning. But it's impossible, of course, in a few minutes to do justice of the richness of the discussion that surfaced. But I'll start by acknowledging how fortunate we were to have Justice Brian Preston on our panel. He's Chief Judge of the Land and Environment Court of New South Wales and brought us a whole series of insights and could answer every question that was put to him about how certain things would work, whether it's expert evidence, ADR, costs, standing. He had the whole panoply of that experience, and we learned a lot from him. But what I propose to do is just highlight 3 quick points, if I may. And the first was one that came from Justice Preston, which was, I think, something that coloured all of our discussion, and his strong view that we can't allow ourselves to be captured by our own particular legal culture and administrative culture here, and indeed by our constitutional law framework, that it's important, he said, to look outside the box and to push those boundaries and to imagine what, for example, a specialist planning and environmental court might look like into the future. And that, of course, is very pertinent because the current programme for government commits to delivering a specialist planning and environmental law court, modelled, it would appear, on the current commercial court. And we were fortunate then to have James Connolly, Senior Counsel, and Karen Dubsky from Coastwatch on our panel to draw in different perspectives. So then, in terms of the specialist planning and environmental law court idea, which is my first point, we concluded that it was absolutely essential that there would be wide consultation around that idea so that people could feel involved in that process from the outset. And important that it's not just one side, but of course, everybody who's a potential stakeholder or a future user of this particular model of court would have to be listened to and engaged with. It was important to hear from Judge Preston about, again, the strategic vision, his very strong consumer focus across all stakeholders engaging with his particular environmental court, a systems thinking approach, and that came out very much as well in some of the other workshops, and a big discussion around the availability of expertise, whether it's at the decision maker, first instance stage, and also then, of course, at the court level, whether, for example, the court itself should have access to independent expertise, and that might then in turn perhaps impact on cost and on the speed of proceedings. The importance of process was also highlighted, and perhaps a role in appropriate cases for ADR, another big discussion, and a separate seminar could easily be had on that. And moving quickly to my second point, which again resonates, I think, with a lot of the other workshops, the importance of basic information for everybody around their rights, the remedies available to them, clear, accessible legislation. There was talk about information around the jurisprudence so that people are aware of what's happening in the jurisprudence, not just nationally, but of course, in the case of the environment, also internationally and from the Court of Justice of the European Union.
One minute, Anya.
The idea of friendly, accessible entry points. Final point then, not unexpected, relates to costs, the importance of certainty on costs, and also not just about who would be liable for costs, but the quantum, the amount of those costs as well. We also touched on the importance of judicial training, and there are a whole lot of other issues as well, but they are captured wonderfully in the chat, and we would hope to pick up on those and develop a more detailed roadmap into the future. Thank you very much.
Thank you very much, Anya. Workshop number 3 was on the legal community outreach, advancing access to justice through education and awareness. And I call on Tractor Regan, Head of Professional Training at the Law Society, to report back on that workshop. Tractor.
Thank you, Jerry. The Legal Community Outreach Workshop explored outreach, education and awareness initiatives. Like Anya's, it was a very lively and well-attended session. We were very privileged to have Mr. Justice John McMenamin representing the judiciary as our opening speaker. And in his opening presentation, he began by discussing why outreach matters, particularly in a media age, in the context of challenges posed to access to justice by a lack of media pluralism and a rise in populism, as is illustrated in many EU countries. He expressed the importance of public trust in the judiciary and an assurance that judges will administer the law independently and impartially. For this reason, he said that legal outreach programs run by the judiciary aim to foster this trust by using creative ways to ensure the public who they serve understand what they do every day. He explained that the district, circuit, high and Supreme Court judges deliver lectures and papers and participate in initiatives of third-level educational institutions and community groups around the country and abroad on a continuing basis. The judiciary also run the Chief Justice's Summer Placement Programme, where students can shadow a judge, attend hearings and discuss cases with their assigned judges. In 2019, the Supreme Court launched the CORA, or Conversation Programme, which is a collaboration between the Supreme Court and the secondary school principals in secondary schools. This programme provides students with the opportunity to ask judges any question they like. We then had Catherine McVeigh on behalf of the Bar of Ireland, and Catherine discussed the Bar of Ireland's Look into Law programme. This outreach initiative provides 100 students from across the country every year with the opportunity to gain an insight into a barrister's day-to-day job and how the court system works. Catherine explained how a minimum of 20 of the places provided are given to DESH schools, with this on some years reaching 40%. This programme counts as a transition year work placement for secondary school students. In 2021, with the impact of the pandemic, the programme moved online and reached 10,000 students last year, thereby removing geographical barriers for those who could not otherwise have attended. John Lunny's presentation on behalf of the Law Society focused on public legal education and in particular the street law method. John explained that street law is an initiative that involves law students and lawyers facilitating law-related workshops in schools and community settings. Access to justice is at the heart of street law, and it is founded on the dual education goals of providing relevant law-related education to meet community needs and to enhance the professional development of law students and trainee lawyers who deliver the programme. The street law programme empowers trainee solicitors through unique intensive induction training so that they can in turn educate and empower their students around their legal rights, responsibilities and options. John said that this approach has shown both short and medium-term social benefits for trainee solicitors, the participant students and prisoners, and for the Law Society itself. Maura Howd, on behalf of the Court Services, discussed the initiatives of the Court Services aimed to educate younger people about specific areas of the Irish legal system, to empower them to be active citizens and to demystify the workings of the court system and its terminology. These include a school tours programme which involves students shadowing a barrister who guides them through the four courts, takes them to a courtroom where they engage in a mock trial, they become the jury and the judge delivers the outcome. Court artists and budding court reporters are also encouraged to attend this. Maura discussed also the transition year work experience programme, where transition year students participate in a week-long opportunity to observe both the courts and the court services. She also spoke about the
1 minute attractor.
Thank you. Let's Look at the Law initiative, which is a new module added to the Civil, Social and Political Education programme for secondary school teachers. And this helps teachers teach their students about the law by educating the teachers themselves. This has been expanded to third level institutions. Colin Smith, on behalf of third level education institutions, spoke about the Higher Education Access Route, or the HEAR scheme, which offers place on reduced points and extra college support to school leavers who are underrepresented at higher education due to their socioeconomic background. He also discussed the access scholarships offered by the King's Inns, Law Society and Trinity College itself and many other universities. He said these programs aim to make the legal profession an accessible career choice for those who, due to their socioeconomic background, would otherwise not have access. They also ensure the legal profession and the judiciary are comprised of people who are reflective of the diversity of the Irish society. He made the point that it's incredibly important that all law schools across the country incorporate human rights training, public interest clinics and legal clinical education, and particular paid credit to you, Mr. Chairman. If I might just make one very important point, we had a very lively discussion about additional initiatives that could be included as part of outreach, and there were suggestions that they should be extended to the Youth Reach initiative, that they should be extended to Board Match to capture those who are not targeted through existing initiatives, and also to support community outreach groups. There was a recognition for a strategic collaboration approach to all outreach initiatives. However, resources and a lack of funding were identified as challenges for this. That concludes the report. Thank you, Chairman.
Thank you very much, Attractor. Mary Carlin, the courts correspondent for the Irish Times, was the moderator for workshop D, which is on accessibility of courts, procedures and legal representation. So I ask Mary to address us now.
Thank you very much, Jerry. We had a really interesting discussion. I would say the focus was on two main themes: the barriers to accessing legal representation and the issue of personal litigants, and how the court system should approach the issue of personal litigants. And that made for a very lively discussion. Our first panelist was Gráinne McKeever, who's a lecturer from the University of Ulster Law School, and she's done extensive research on litigants in person in Northern Ireland, and she talked about the various barriers to litigants in person. She described those as practical, emotional, intellectual and attitudinal. The practical ones include the attempt to get assistance, inaccessible information, that litigants don't even know where to sit in court. There's a cost barrier as well. And then the lack of information about how they can get lawyers and the difficulty of following issues in the hearings. The emotional barriers include that when they're actually within the system, there's often frustration, anger, anxiety, and a lack of trust. There's also issues that the court actors don't value them, and that regard them as disruptive and essentially an attitude they shouldn't be in the court in the first place. And then she looked at how that might be addressed, and she put it quite succinctly in 3 points. You can either give them lawyers, make them lawyers, or you can change the system. So that made for a very interesting discussion when that moved on. Our second speaker will be well known to everyone, Senior Counsel Turlough O'Donnell, former chair of the Bar Council. He spoke about the work of the bar in the pro bono area, its voluntary assistance scheme, and the conversations between the bar and the voluntary sector and the charity and charities. The work that goes in by lawyers involved in the pro bono scheme in relation to research, draft pleadings, advocacy, training, and encouraging people to speak for themselves. He talked about the digital advocacy and engagement with, sorry, can't read my own writing, and engaging with various actors. And it also provides advice on charity and private benefits. And Turlough made the point that through all that engagement, that lawyers have learned as much from the various other actors as they have from them. The third speaker was Gary Lee from the Ballymun Community Law Centre, and he talked about what happens very much at the coalface of dealing with probably the most disadvantaged sectors in society. Like, he spoke about that about 70% of the clients of the centre have a disability of some sort, whether it's a physical or emotional disability. And about kind of overcoming issues, including the view of many clients that the law is against them and it isn't for them. And he spoke about it's a small thing that impact on their clients, issues like social welfare and entitlements, family law. And he said he was making the point that in the pandemic, employment issues have very much come to the fore.
Mary, 1 minute.
He also made the argument that states should fund community law centres. Eamon Conlon talked about the moral duty of lawyers to do pro bono work, and it shouldn't be left to just frontline lawyers like Gary and community law centres and those engaged in that kind of work, that all lawyers have a moral responsibility. And our final speaker was Judge Francis Comerford from the Circuit Court, and he was a member of the Civil Law Administrative Reform Group. But his address focused very much on how the courts should approach the issue of personal litigants. And that made for a very lively discussion, because Francis doesn't believe that encouraging personal litigants is good for improving access to justice, quite the contrary. And he said the essential point is to improve equality within the system. And the way to do that was to get everybody lawyers. He stressed that when people are there in the courts as litigants in person, the courts have a duty to assist them. But the overall, it isn't what that shouldn't be the goal. He argued that proper access to justice required more extensive legal aid, and that some personal litigants do pose difficulties for the court system. And Grania came back on that in the discussion, that we should be looking at what outcomes do we want to achieve, and who actually is the system for? Is it for users, or is it for the legal profession and the judiciary?
Thank you very much, Mary. Philip O'Leary, Chair of the Legal Aid Board, was the moderator for the fifth workshop, which is on access to legal services for people in poverty and disadvantaged groups. Philip.
Thanks, Jerry. And if this was the Eurovision, this is the vote of the Cork jury, and I did promise you I'd finish on time, so I will. I emphasised at the start that there was a lot of lawyers online, but that we should take off our lawyer hats for the workshop and try and focus on the experience of the end user. I asked the panel to think about what are the barriers to justice for people in poverty and disadvantage, and how can NGOs and other organisations and lawyers work to provide legal services for these people. Our first speaker was Mark Willers, QC, who has written the book on gypsy and travel law in England. No such book in Ireland so far. There's a lot to say about this area of law, but very few people actually working and writing on it. Though speaking from an English perspective, discrimination faced by travellers here is much the same as in England. Affordable legal advice is thin on the ground for travellers. They face discrimination across many sectors and suffer as they don't have access to justice. He emphasised we need to have training sessions for lawyers. And he was echoing Professor Trevor Farrow that access to justice makes economic sense. Mark also mentioned the very important collaborative project between the University of College Cork and the FLAC on traveller equality and justice. And I know that the Legal Aid Board has been trying to lend a hand on that recently as well, which is a good thing. Our second speaker was Brian Killoran, who was the CEO of Irish Immigrant Council. And he spoke on the theme of the need for migrant communities to have access to mainstream legal aid, the need for access to legal aid to be gender, culturally and linguistically sensitive. And I think that's something we really have to look and listen to, even from a Legal Aid Board point of view, in terms of how we go forward. And he made the point in general that none of us can figure out these issues independently, but together we can create an action plan, and that kind of feeds into the common themes we had over the course of the conversation. Our third speaker was Justice Mary Lafoy, and she spoke about SAGE advocacy, of which she is chairperson, particularly on the need for there to be independent advocates who support vulnerable adults and older people going through the justice system. She's hopeful that a statutory scheme will be introduced for this, and that the 2015 Assisted Decision Making Act allows for this. But as was pointed out, we have to be conscious that even when there are systems in place, they have to be monitored, and they have to make sure that these systems themselves don't become a source of exploitation. Our final speaker was Tricia Keelty, and Tricia is the head of policy with St Vincent de Paul. She spoke about access to justice isn't often the issue that people present with when availing of SPP services, but is often there in the background, especially family law proceedings, as lone parents are the group most likely to be accessing SVP resources. She said legal issues can trigger non-legal issues and vice versa, and there's an inextricable link between access to justice and poverty. I was surprised to hear myself, and I shouldn't have been, that people are coming to St Vincent de Paul to get their contributions to the Legal Aid Board to be paid, which is a shocking indictment in lots of ways. I mean, just a final point, the common themes that were arising were themes that were raised not only by Trevor Farrow when he talked about a cascade of problems of those living in poverty, but I heard Eilish Barry refer to the cluster of legal problems that can occur, and particularly for people living in poverty and disadvantaged groups. And the final discussion centred around the need to be joined up thinking from all the concerned parties, NGOs, people living in poverty, particularly so that we can feed into the review of civil legal aid, which is a very important thing that we are hoping will commence this year. And that was the end of our conversation today. Thanks, Jerry.
Thank you very much, Philip. The final workshop was on equal treatment in the court process, and the moderator here is my colleague at Trinity, David Fenley, and chairperson of FLAC. So, David.
Thanks so much, Jerry. And I think it's fair to say, Jerry, that very few people have contributed as much to the debate on access to justice over the last 40 years in Ireland than yourself. So it's fitting that we have you chairing this final session. In our session, we looked at how, despite the promise of equality before the law under the Constitution, the reality of accessing justice in the Irish legal system is much more challenging in practice, a theme that we've heard a lot about over the last few days. And we focused on how that constitutional guarantee of equality is upheld in the day-to-day operations of the justice system. And we had a rich range of perspectives, and I won't be able to do them justice in the few minutes we have here today. We kicked off with Robbie Sinnott, who's a well-known campaigner for disabled people, who offered searching perspectives on the challenges faced by disabled people in accessing the court process at all stages, including in accessing legal representation at an early stage, and also the challenges, for example, for blind and visually impaired persons of self-representation before tribunals. So really, Robbie's contribution emphasised the importance of disabled people's organisations and other groups being heard as part of the court process and the reform process too. And this was a theme that was echoed by Susan Kennefick from the National Disability Authority, who shed light on the existing obligations on public bodies, including the courts, under disability and sign language legislation. These affected procedures, the infrastructure of the courts, also the duties on individual personnel within the system. And Susan pointed to the low levels of awareness about these duties and the need to drive greater compliance. We then heard from Fiona Johnson from UCC, who works on the Traveller Equality and Justice project that Philip just mentioned. And Fiona used her contribution to bring some of the voices from the community that the project is working with into this discussion, emphasising the challenges faced by members of the Traveller community at all stages of the court process, and even before issues that might have a legal dimension become legal issues proper. And Fiona really emphasised the importance of hearing these voices within our process, again, bringing them into the heart of reforms that may be considered or underway. Fiona Donnelly from the Institute of Professional Legal Studies, Queen's University Belfast, spoke about the challenges faced by vulnerable persons in the court system, giving great examples by reference to autistic persons, and how the legal system needed to be tailored to accommodate these different needs. Fiona spoke about the need for the system to be disability and vulnerability agnostic so that it ensures equality for all in practice. We then heard from Bashir Otakaya, who's from DCU, who talked to us about how the courts needed to reflect the changing nature of Irish society. You can't be what you cannot see, Bashir said powerfully. And this was something he said that we needed to consider in all aspects of our legal system, including in the composition of the judiciary. He pointed to the need for diversity and inclusion training across the system and proactive compliance with the public sector duty. And that was a topic that was picked up upon by Sinead Gibney, the Chief Commissioner of the Irish Human Rights and Equality Commission, who spoke about the potential of the public sector equality and human rights duty under Section 42 of the 2014 Act to transform our legal system and our courts system specifically, and the need for greater consideration to be given to the process of assessing, addressing and reporting on equality and human rights systems that affect the issue. Judge Tamara Lewis, who's an employment judge in England and Wales, spoke to us about the role of the equal treatment bench book in the English legal system, and how this provided support and guidance to the judiciary at all levels in dealing with ever increasingly diverse group of court users. And that was a very helpful discussion. And then finally, we heard from Ms. Justice Irvine, the President of the High Court, who spoke about the steps taken by the courts to facilitate access to justice for, again, an ever more diverse group of court users. She spoke about the challenges, but also the opportunities presented by some of the developments we've seen during the pandemic, such as remote hearings, but also the need to ensure at all stages that the court system works for those that it is dealing with and that it affects. And finally, Ms. Justice Irvine updated us on the significant progress that's been made in recent time in the context of judicial training, including on unconscious bias. Yesterday, Jerry, the Chief Justice, spoke about us using this conference to find some paths forward. In our panel today, we identified some challenges, and identifying those challenges is probably the critical first step in moving forward. But we did find some useful avenues that we might explore, such as engaging proactively with the public sector duty, and tools such as the equal treatment bench book, which we could probably draw upon in this jurisdiction. It's a key resource for judges, of course, but also for all practitioners within the profession and anybody who has to navigate the system. And really, all of this underlined that the nature of the challenges we face in this area are such that they can't be tackled by any one individual or any one institution alone, whether the courts or otherwise. This is really an area which calls for and requires collaboration in the common aim of pursuing equality before the law, but also access to justice, which this conference is concerned on. And we concluded on the note, Jerry, that this, we hoped, would not be the end of the conversation, but merely the start of it. So with thanks to the Chief Justice and all members of the working group and all the team involved in organising this conference, that concludes our summary of Panel F.
Thank you very much, David. So we've concluded the session slightly over time, but hopefully within the margin of appreciation. Before I hand over to the Chief Justice and to the designate Chief Justice, Mr. Justice O'Donnell, can I just take this opportunity to associate myself with the compliments that have been paid over the last 2 days to Chief Justice Frank Clarke for his public service, and in particular for highlighting this important issue of access to justice. And I'd like to commend him and the organisers of the conference, this weekend's conference, for this particular event, which doubtless will be a catalyst for important steps going forward. So I hand over now to the Chief Justice and Designate Chief Justice. Thank you.
And I think we've agreed, Jerry, that I'll go first. And because I'm the past, I suppose, and Donal is the future, and it's probably better that the future comes after the past. Can I just start by again thanking everyone who's been involved in this conference. I thanked those who had set it up yesterday, the working group, which I think formed a very coherent, effective, but friendly group of people, which allowed us to get on with the work. Those who helped us, both Anne and Ellie in the Law Society and their team, my own staff from my own office, Sarah Rose and Patrick, and all of those who were involved. And then today, as we've just heard in a whistle-stop tour, a huge number of contributors, moderators, have given a lot of thought into the diverse areas where we need to pay attention. And I'd also like to thank our own Supreme Court judicial assistants, one of whom attended each of the workshops. And it's perhaps there I'd like to start. If one was obvious from the last half hour, it is that we got a very brief glimpse of what was happening in very rich conversations across a whole range of areas. And if that was all we ever were going to get from it, that would be of some use, but of some very limited use. And I'm hopeful that we will arrange to have a much more detailed account of what happened at the workshops to inform the way we move forward. And I want to thank those JAs because it was a difficult task. And I look forward that perhaps the workshop the working group may be able to consider publishing all of the contributions, the accounts of the JAs, of the works of the various workshops, and also the keynote addresses that were given yesterday. But as David Fennelly just said, that would be all very interesting and very nice and people talking to each other. But if it doesn't lead to anything practical happening in the future, it will have been of very limited value. So really the issue is, what do we do with all of this information? And I think themes that were there at the very beginning have been, if anything, in my mind, reinforced. There is a huge interconnectivity between all of this. No one group has all of, well, even if you had all of the answers in your head, you don't have the capacity to deliver on all of the answers. It requires a roadmap which takes into account a whole range of different problems. It requires bringing on board government. It requires bringing on board many others, the practicing professions, those who have insights into the unmet needs and how those unmet needs might be met. And that really is the next stage. I think it probably does involve engaging with a wider group, as Eilish said this morning, and building on what we have learned. I even get the impression that even if we had a verbatim account now of the works of each of the workshops, that would still be only scratching the surface in many areas of the issues that were discussed. And in one sense, each of those areas would warrant a conference of its own, but in another sense, that might slightly devalue the overall picture because it's clear there were common themes to the various workshops and perhaps overlapping solutions potentially deriving from those common themes. So I think the first step hopefully will be that we will go away and reflect, not at too great length, because the real world keeps moving on out there and people who don't have adequate access to justice are suffering disadvantage because there aren't solutions to these problems. So it's not a matter to be solved at leisure, but at the same time to reflect on what we've learned and to devise what are the next steps to ensure that this doesn't turn out at the end of the day to being a talking shop where people, at least in the round, like-minded, persuaded each other that we were all correct about everything, but rather was an occasion which laid the basement foundations for putting in place measures that over the next number of years may do something genuine about improving access to justice. I'm happy, to the extent that anyone wants me to continue to play a role in this, but it'll also be important to hear from Donal O'Donnell, who will, I think, in 9 days' time, take over my day job and will also have a role in bringing this forward. So I might hand over to Donal at this stage.
Well, thank you very much, Frank. I'm very pleased to be able to participate in this conference. I know that some lawyers and commentators might say that the business of courts and judges is to determine the disputes which citizens bring to them, and that they should have no role or interest in whether people come to court or not. I take a different view. I warmly welcome this conference. I think it's particularly appropriate that the Chief Justice has organised it. And picking up on something Eilish Barry said this morning, I would like to continue to build on the work of this conference and the working group in the years to come. Yesterday, Judge Shifra O'Leary of the Court of Human Rights mentioned the fact that the significance of the decisions made by courts lies not just in relation to the decision in an individual case, important though that is for the parties. It also lies in the fact that those decisions, large or small, control a much wider field than just the dispute between the parties in the case. The decision in itself and the capacity it gives to lawyers and citizens to predict future decisions controls or at least influences the life and conduct of people who might never come to court. And Professor Farrow yesterday described the fact that legal advice is much more significant in affecting people's reaction to law than going to court. And to that extent, the decisions of the courts are a vital strand in the fabric of society, which hold it together and at best make it strong. Without, I hope, undue complacency, I think it can be said the quality of justice dispensed in Irish courtrooms is high and is certainly well respected by international standards. But there's a danger of a mismatch between the quality of justice dispensed in a courtroom and the impact of the law on the wider society which it seeks to serve. A good decision might be made if a case reaches a court, but if the cases which come to court are only a narrow and shrinking subset of the disputes that citizens have and wish to be resolved, then the capacity of the administration of justice to be a vital part in the structure of a humane society becomes compromised. If people do not know that the law provides an answer to their problem or a way to resolve their dispute, if they do not think they can get into court, if they cannot afford to get there or at least take the risk of a loss, if they cannot get into court because of delays that are too long, then the care and attention with which justice is dispensed inside a courtroom looks less impressive, more random, and people, perhaps justifiably, become more skeptical of what lawyers like to call grandly the rule of law. The distinguished American jurist Lon Fuller, in his 1969 book, Anatomy of the Law, wrote about the state of the law as it was then perceived in the Soviet Union. The Constitution of the Soviet Union spoke in resounding terms about the rights of the people, but the law was not respected or regarded as a worthwhile profession, and as Lon Fuller put it, for the man in the street or in the field, the most common response to the law was a gesture of helplessness and indifference. The law was like the weather. It is there, you adjust to it, but there's nothing you can do about it except to get under cover when its special kind of lightning strikes. Now, I'm not suggesting we are at that point here. The law we have is not the will of distant rulers imposed upon the people. It is, by and large, law which tends to protect the weak from the strong, which seeks to maintain order and prevent chaos. There are very many people working in the legal system, lawyers, the staff of the court service, and judges who work very hard to make the legal system work for the benefit of all citizens. But access to justice is critical. It is and should be a matter of concern to judges and lawyers and anyone interested in making society fairer, more humane, more considerate, and ultimately more secure. The second reason I particularly welcome this conference and congratulate and commend all the contributors is that indeed, as the Chief Justice said yesterday in opening the conference, it's based on a recognition that removing obstacles to access to justice is not a single problem with a single solution, but a multifaceted problem that requires many changes, large and small, in many areas. It certainly involves education, outreach, and support. It involves voluntary initiative by lawyers and the structured support by the organised branches of the legal profession. It also involves a stronger and more effective legal system. It may, as the Minister said yesterday, involve provisions controlling the costs of proceedings and, as importantly, controlling the procedures that lead to costs, and may involve other initiatives that have been touched on in relation to representative actions on behalf of groups and the possibility of third-party funding. It may also involve further litigation, whether in the Irish courts or in the European courts, as discussed by both Judge O'Leary and the Chief Justice yesterday. Some people may find this range of issues and tasks depressing, but I think it is both pragmatic and at one level encouraging. It means that we can all make a difference in different ways. There are many ways in which access to justice can be improved progressively and incrementally with a significant cumulative impact. It's not a job for one group or one initiative. It's a job for us all. And in that context, Judge O'Leary discussed yesterday one case, McCann and the judge of the Monaghan District Court. That was a case which challenged and ultimately led to the striking down of the provisions for imprisonment for debt. It originated in what was then the Northside Community Law Centre and came to the Bar pro bono scheme. And I was honoured indeed to act in that case. It resulted in, if I may say so, characteristically excellent judgment by Miss Justice Mary Lafoy, who I'm pleased to see here today, which was so compelling that it wasn't appealed to the Supreme Court by the state. In fairness, perhaps, things were already shifting at a policy level, and it may be that the case and the judgment were a catalyst in bringing about a change in that area. But I thought then, and I think now, that the most significant piece of lawyering in the whole case was that the then solicitor in the centre, now Judge Colin Daly, who on at least 3 occasions went to Monaghan in wintry conditions to seek to prevent the court making an order that would of ultimate imprisonment for non-payment of debt, even though that would have the effect of destroying the case as a possible vehicle to challenge the legislation. And that was an example, I think, of a multifaceted approach. It meant that when the case came to court, it was not a cipher just for a legal argument constructed in an affidavit. It was demonstrably a case that had affected the lives of real people and showed that access to justice is important, not just because of its policy significance, but because of its capacity to affect the lives of real people in their day-to-day lives. Now, that's one case, but perhaps one of the most important cases, and I think inspirational cases decided in the Irish courts in the last half century is the State Healy and Donoghue. I remember as a young lawyer making my way seeking judicial review of cases in which legal aid had been refused to criminal defendants, admiring the judgment of the then Chief Justice Tom O'Higgins, and marvelling indeed at the judgment of Seamus Henchy, and I'm afraid recognising myself when he described the need for legal aid, even when the matter appeared straightforward, because of that fumbling incompetence that may occur when precipitated into the public glare and alien complexity of courtroom procedure. That decision not only continues to be cited, it continues to be a rich source of inspiration, encouraging further developments in the law. To borrow a phrase from another area of law, it is certainly not beyond the age of childbearing. And it's particularly appropriate to consider that case in the present context. The late Rory O'Hanlon acted as senior counsel pro bono in that case, and there were 2 junior counsel, the most junior of which is recorded in the Irish reports as Mr. G.B. Clark. There are a decreasing number of people who know that Frank was once George Bernard Francis, but it is perhaps particularly appropriate, therefore, that a career at the bar, which started with groundbreaking litigation on the subject of legal aid, should come to a close as Chief Justice promoting a cross-disciplinary conference on the broader policy questions involved in access to justice. That is perhaps its own example of a multifaceted approach to the issue. I hope that the initiative that this conference represents will stimulate developments large and small. I congratulate and commend everyone involved in this conference who has given their time, energy and expertise to it. And I hope we will be able to maintain and indeed develop the Chief Justice's working group on access to justice in the years to come. Thank you.